Mm-hmm. Hello. Thank you for the 19 months, Becca. Hello, thank you for the 6 months. Oh, hi. Uh-oh. Oh. It kind of helps to have my camera on. I didn't even know I didn't have it on. We should be good. Hi. We got, I've already checked in, for my flight, tomorrow evening. Hopefully it doesn't get delayed because of the weather. That's like the biggest concern that I have right now, but I'm sure we'll get there. Where's my face? Oh, hi. There we go. How you guys doing? We gotta go with a couple of, at least one airport, and then we're gonna go for a courtroom. I know that Lane Myers' thing is like 2 hours long. I'm not gonna get through that. I ain't getting through all that. I know that for a fact. But we'll see what we can get through this evening. Just me already yawning. My babies. Both of my babies are here for once. I got Serana here, and I got Maik in the hammock. Let's see here. So in terms of like YouTube, or not YouTube, my computer, I've tried one last alleged solution. I haven't tested it yet, so I haven't opened up any games yet. I don't know if it's gonna work. I'm so pessimistic right now because I feel like I've tried everything. I feel like I'll have no choice but to wait for Nvidia to drop a new driver that's not going to break my graphics cards. But yeah, I now find out that I know what the little tags are in the chat. Apparently, YouTube added these community leaderboards things, a la Twitch. The problem is that they reset every stream. And so the way I believe it works is that you get points or you get XP based on how active you are in chat, based on super chats. Let me see here. It's live chat messages, super chats, and super stickers. So if you're the most parasocial in the chat, you'll get recognized as such. So it's very newfangled. Okay, Hitchbot, you're you need to chill. Also, other news. I did not get the alcohol package last night, and today they lowered the discount from 45% to 32%, and therefore it's basically absolutely not worth it. So, oh well, I'll have to just count my drinks as I'm there. So, all right. I don't know which airport this is in. I feel like it could be Orlando or Dallas. I have no idea, but I guess we'll find out together.
On May 3rd, 2023, police were...
I cannot wait till this shit's on YouTube.
On May 3rd, 2023, police were called to assist with a situation on board a commercial flight involving an uncooperative male passenger.
113, yeah, it looks like he's...
All right, this is I think it's Orlando.
Better do it now.
37.
Sir! Come here!
god! That's my flight!
No, it's not.
It's literally my flight! I'll show you.
Stop, stop.
Okay? Okay.
You've been denied getting on a flight.
Yeah, I don't understand why, but...
Oh, yeah, sounds very
Have a
drunk.
seat right here. Have a
Whoa.
seat right here. Have a seat right there.
Let go of me.
Have a seat right there.
Let go of me.
Have a seat
First
right
of all,
there.
no, I'm not gonna sit. I will show you exactly
No, I
my
don't
flight
need to see that. Let me
itinerary.
see your ID.
Really?
Yeah, let me see your ID.
You're gonna pull the
What the hell? Is he like, is he wearing his like jacket like a scarf?
hardcore shit.
Stop it.
Alright, go ahead. Go ahead. There's my fucking ID.
Have a seat. Have a
That's
seat.
my fucking flight.
Have a seat.
Ooh. Oh shit!
Stay down. Stay down.
All right, well, that officer was not playing today.
Come on. You got
Are
it?
you fucking kidding me? Fucking kidding me?
Good job, hero.
I cannot wait till this shit's on YouTube.
Well, today's your lucky day.
I can't wait. I can't wait till this shit's on YouTube. You pieces of shit. Garbage pieces of shit. Garbage pieces of shit. Go ahead. Reese's in my shit. You guys are garbage pieces of shit. Right?
I don't have a
Right?
cage car over here.
Yeah!
Oh my god.
Doggone right. Oh shit! This is an American citizen.
American citizen.
I'm an American citizen.
Okay.
You guys are fucking idiots. I'm an American citizen.
Oh my god.
Oh shit! You guys are American citizens. Oh shit!
Boots here.
Go ahead. Go ahead. Look for it. Go ahead. Go ahead. You done. I'm empty. Yeah. Yeah. I'm empty. You
Taking the truck court out
yeah. I'm fucking. There's no reason to fucking apprehend
He's
me.
gonna fight and kick all the way to the truck court. Yeah,
Hey, listen.
Oh, you already called for him?
I called for a cage.
Hey, listen. I'll tell you guys right now.
It's coming up here. We're gonna need shackles.
Hey, I'm calm. If you guys want to let me go right now, I'll go and enjoy my vacation.
I mean, you guys denied him at some point?
Yes, I'm the supervisor on duty.
Okay.
So Enrique here was the ops agent. I was the supervisor on duty. I was called to keep an eye on him. We originally let him work. It appeared that he was on the spectrum, but he was not anywhere near the vocal.
And that was originally 36?
That was at this one of these meetings. Yeah, 37 right here.
Okay.
And that was probably about an hour. When was the national budget? Probably about an hour and a half ago by now. And he was not anywhere near the ambulance. I let him go within the flight crew. Noticed something about how he was talking towards some passengers as he was boarding, so they did not feel comfortable. So I facilitated the denial and I said, how you're appearing right now with your behavior, we're going to get you to book you for tomorrow morning. So he didn't like that. He was like, I'm going to follow you, but I'm not going to come humbly. So he was being a little weird like that. But
He
we got him
eventually
off,
got off. Okay.
and we rebooked him, and he gave me a hug even and all that. So we knew he was drunk, but he wasn't anything like that until after we had finished him. And then he tried to go over to Mr. James's gate over there, who was boarding a different flight, thinking that was his flight. Like, no, sir, we rebooked you for tomorrow.
That was 30. Is that
That was
38?
at 38, but he did not go on that bridge.
Right.
So I walked him back out to the walkway area, and then he kind of paced back and forth by the fish tank, which is when he called you, or called the
Fish
dispatcher
tank.
saying, there's the guy that's being struck.
Okay.
So then, as you guys approached, that's when he saw Daniel open his gate to meet this is Ron, the plane here that's just staying overnight. So that's when he took it on himself, thinking
Went down
that
there,
this was
right.
his plane, because he remembered this was the gate he was at
Right.
earlier. So he just followed.
And then you
him.
guys like kind of were stopping him.
Oh,
and
we
then
stopped.
Well,
down.
he went down, and I turned around, like, because I was checking on the woman who was sitting there. I turned around, I saw one of your guys coming over, and like, come on.
Yeah, that
and
was
I
me,
turned around,
yeah.
and I was like, I don't see him. And then I heard Daniel yelling.
Right.
I was like,
Did
shit,
you have to
he's
like
down the
physically
jet
stop
bridge.
him?
I didn't touch
So-
him. He was probably like maybe about this far away.
Right.
He was pleading to get on the plane. I told him he needed to leave. I kept yelling that he needs to leave this jet bridge now.
Okay, and that's when you
And
went
that's
down.
when I went
never
down
opened the
and went in
plane door.
between the two of them and just went like this. I said, you're not getting any
right.
further. I said, and you don't want to touch me, because if you touch me, it's a federal
And he
offense.
didn't hit any of you guys?
No.
Okay.
I'll go in there. I want to ask him this question.
I mean, I was banned from my own chat.
Excuse me, sir.
Yes, sir.
You told me I could ask you one question. Yes.
Sure, go ahead. Knock yourself out, brother.
Stay here.
I'll be right back.
Throw it down the cellar.
I'm listening, man.
As my Medicine right. Why am I getting thrown down the cellar?
You got disorderly intox. You got resisting arrest.
I didn't do any of those things. I didn't do any of those things.
Well, you were told to sit down. Then
I didn't do any of those things. Sir, I didn't do any of those things.
Sir,
Fantastic. Walk down the stairs.
sir.
We're hiring you. You want to come too? I didn't do
Only if I could be in the airport.
Yes, that's us.
Big gig.
That's gonna get a big one.
Tampa, there we go. Hey, Tadale. Bye, Tadale.
Oh, you got it.
There we go.
Why would you put your hands down there?
I'll tell you what. I think we got a hobble rope.
I got one too.
It won't
Good
work.
for you. I mean, you can. I don't think it's necessary. It's up
Oh,
to you.
okay. Okay.
That hurts.
Well, why did you put them down there?
I don't. You guys put me like this.
No, nobody put you like that.
Yeah,
They're behind your back. You
you
worked
guys-
them down for you.
He put them back. What a dumbass.
Oh!
Why would you do that to yourself?
Oh!
He drops his weight too.
Yeah, I know.
Oh! Look!
You been pending on her?
Are you guys kidding me? This is really what you're fucking. This is the national security? Really? Really?
Really,
Yeah. It's my AirPods, buddy.
All right.
buddy?
Watch your head when
Wow.
you get in there.
Turn around.
Sit down with
Sit
your
down
butt first.
National citizen.
Pull your feet in.
You guys are the biggest pieces of shit I've ever seen.
Okay.
The suspect was charged with disorderly conduct for causing a disturbance on board the aircraft, public intoxication due to signs of alcohol impairment, and resisting arrest after failing to comply with officers.
Here's how this process works. It's not how little can you tell the judge to make it happen for the way you want it to go.
Services. That sample was sent in and returned with positive confirmation from Redwood Toxicology on May 20th. Also on May 19th, Mr. Proctor did admit to drinking wine the day before the drug screen.
Oh.
He admitted that during an office visit. I would also like to note that Mr. Proctor is currently on bond conditions, which allow him to participate in our program.
Is there also a second potential violation?
Oh, yes, Your Honor, thank you. On May 20th, Mr. Proctor was pulled over by the City of Gaylord Police Department and cited for a DWLS. He did advise of that situation or incident rather during an office visit too. Again, he is still on bond conditions to participate in this program. And if the court doesn't have a copy of that police report, I can hand that over.
I do have a copy. All right, Mr. Proctor, Mr. Brown, you've heard the allegations. Mr. Proctor, you have the right to have a hearing on those matters. That would be in front of me as a judge. You do not have the right to have a jury trial. You have the right to see, hear, and question the witnesses against you. You do have the right to be represented by an attorney. You understand the rights that I've just given to you?
Yes, sir.
All right, Mr. Brown, how does your client wish to proceed today?
Your Honor, at this time, I believe he is going to make admissions to the drinking. However, we would request on the driving on a suspended that be adjourned, as it appears he may have picked up a new charge on that, which is currently pending.
Oh, no.
All right, Mr. Hamlin, do you wish to proceed as to the DWLS charge if it makes an admission to the drinking charge?
Yes.
All right. All right, we'll take the plea as to the drinking charge, and we will postpone and adjourn the DWLS to allow that to work its way through the court system, and then we'll readdress that in the future. Mr. Proctor, would you raise your right hand, please, so I can swear you in? You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? All right.
Yes, sir.
You've heard your lawyer indicate that you wish to admit this drinking violation. Is that correct?
Yes, sir.
Has anybody promised you anything or threatened you in any way? Has anybody threatened you in any way to get you to enter this plea?
No, sir.
You're doing this of your own free choice and free will?
Yes, sir.
All right. Can you tell me what you did regarding May the 16th that makes you believe that you're responsible for drinking on that date?
Oh, yeah?
I just messed up and had a drink. I had a glass of wine with my grandma. I dropped dirty.
You knew that you were on bond conditions that prevented you from drinking at that time?
I was on the original bond conditions, yes.
All right. All right, I will accept your plea. Find that you've given me that plea knowingly, intelligently, and voluntarily. Mr. Hamlin, how do you wish to proceed as to disposition?
Just a moment, Your Honor. Your Honor, I'm going to ask that the prosecutor give his notations on this.
Mr. Portier?
So, Your Honor, given the fact that he signed and acknowledged the bond conditions
for the 41 month.
For the program.
Hey, Father, thank you.
On May the 15th, and
thank you as well.
24 hours later, tested positive for alcohol. One of the conditions that's actually listed as number 3 is you are not to purchase, possess, or consume any alcohol. I think at this point, given how quickly that violation occurred and the fact that there's a pending charge and we're adjourning the other portion of this, I think it would be wholly appropriate at this point for Mr. Proctor, when he gets back to the state of Michigan, that he turn himself into jail and a new bond be issued at that point.
Mr. Brown, your response?
Hi, Your Honor. I did have conversation with Mr. Proctor. He knew that he had messed up. I believe his grandmother is in poor health. They were talking. They sat down together and had a glass of wine. That he was not driving. He wasn't getting drunk or anything. But it was still against the bond conditions. He knew that. I would give him credit here for not trying to say it's a false test or something like that, and that, you know, he was very straightforward about it. He knew the potential consequences here, yet he still didn't try to cover it up. So I would ask court to consider that when imposing it. And if Mr. Proctor can elaborate on that as well.
Oh, boy.
All right, Mr. Proctor, you also have the right to tell me what it is that you think I should know prior to the imposition of sentence. This is your opportunity, sir.
Dustin, did you want to say something? Looks like he might have froze up.
Joys of technology.
Your Honor, I'd like to say too that I did tell Mr. Proctor if he is in a dead zone or knows where one's coming up, he should be in an appropriate spot for court.
Mr. Proctor, can you hear us?
Hello.
I would like to say that I didn't have the glass of wine after Thursday. I had it on Thursday. I had it on Wednesday. Going above the hill.
You're going to have to try to say that again, Mr. Proctor, and speak a little more slowly. you have a telephone number for him, Mr. Brown?
I do.
Did you call him
we
and
lost
tell him to
him.
get on his phone as opposed to the whatever he's doing now?
Sure, Your Honor. Just give me one moment, please.
Can you hear me?
Hello.
I can, Mr. Proctor.
I'm so sorry. I always have service here. Pull over somewhere, D.
All right, Mr. Brown is here. Go ahead, Mr. Proctor. Why don't you repeat what you tried to say before?
I was trying to let you know that I did not have the drink after I got into drug court. I understand it was still on bond conditions, but it was not after I got into drug court. It was before I got into drug court.
Okay.
I'm still taking ownership to it. I wasn't supposed to, and I messed up. I get that, but it wasn't right after I got into drug court.
It's on May 16th, right?
I dropped dirty on May 16th. I had the drink on the 14th.
You still didn't have alcohol in your system from a drink on the 14th when you tested on the 16th.
I've tested dirty like that before.
What? Wait.
Last time I was in drug court.
If you're going to tell me stuff like that, things are not going to go well.
I'm just saying, I didn't drink the day of drug court.
Okay. Now, I'm just a layperson, but I'm pretty sure. I mean, I'm only a layperson. I may have to reach out to people who know better. But how long does alcohol stay in your system? After you stop drinking? Because I would expect it wouldn't be more than like, what, 24 hours if you just stop drinking? So, if they're saying that he tested positive for alcohol the day of drug court, but now he's claiming that he had the glass of wine the day before. Is
that what you want to stay with?
I'm taking full ownership of drinking.
Full ownership of what? That you drank on the 14th and tested positive on the 16th?
We'll go with 15th. I take full ownership for drinking, and I shouldn't have drank.
Okay, Mr. Proctor, do you know how alcohol works in the body?
I don't know how anything works in the body, sir.
Yeah, you drink
Okay.
it and it goes away relatively quickly. Like within an hour of drinking, you've lost a substantial amount of alcohol that you consumed already. If you had one drink, probably within 2 hours, there's no alcohol left in your body. You can't test positive a day later from a one drink of alcohol.
Yeah,
so you're lying to me someplace, or you're lying to yourself. Either way, it's not a good thing.
Yeah,
I had more than one drink, but we'll go with I had a drink on drug court, so I apologize.
It's not a we'll go with. Tell me what actually happened.
Yeah.
I had a drink.
How much did you drink, and when did you drink, and where did you drink?
I had three drinks.
Oh boy.
When?
Drug court day, Thursday.
Okay.
What time?
So, before, he tried to switch his story up, saying, oh, actually, you know what? I had one drink the day before drug court, but now he's switching it again, saying, okay, you know what? Not only did I drink on the day of drug court, I had 3 and not just 1.
Well, I got out of work at 4, so after 4.
4 in the afternoon or 4 in the morning?
Afternoon.
When did you test?
Friday at 8, I think.
So what did you drink? It's going to still be in your system 12 hours or 8 hours later.
I had 3 drinks. That's all I had. My grandma's right here with me.
Well, so far we've gone from 1 to 3. You want to try again?
I only had 3 drinks.
We didn't have that.
Here's how this process works. It's not how little can you tell the judge to make it happen for the way you want it to go. It's you tell me the right way the first time.
I understand, sir. I'm sorry.
Uh-huh.
How old are you, Mr. Proctor?
35.
Have you not figured out how to tell the truth yet?
I have.
Have you?
Well,
I apologize.
I don't think you understand it then, because you just lied to me in court.
Yeah, you did.
Anything else you want to say, Mr. Proctor, on your own
sir.
behalf?
No, sir.
Congratulations.
How long are you going to be out of the state, Mr. Proctor?
I will be back on Friday.
Friday is May 30th.
Yep.
What time on Friday will you return?
I won't be returning until 8 or 9.
In the morning or in the evening?
In the evening, depending on drug testing.
Saturday morning, 8 a.m. Report to the jail.
Your Honor, can I ask for 9 a.m. if he has to drug test? That gives him.
You done fucked up now.
Yep. 9 a.m. so that you can drug test Saturday morning. Report to the jail for 2 days. You'll be there Saturday and Sunday.
Can you release him Sunday?
Weekend jail.
After 10 a.m.
Yep.
Thank you.
From 9 a.m. Saturday till after 10 a.m. on Sunday. You understand, Mr. Proctor?
Yes, sir.
That's not only for drinking, but that's for lying to me. It
Yep.
gets worse as it goes along, so don't continue that behavior. Do you understand?
Yes, sir.
Yeah, you don't.
All right, that's all for today.
Congrats.
Thank you, Mr. Brown.
Moron.
Court does call the case of the People versus Stephen Johnston.
Okay, Richard McDuffie for the people. And Allison on behalf of the people, Your Honor.
Assistant Public Defender Nicholas Bukovich on behalf of Mr. Johnston.
All right. I put this over to this afternoon.
All right, so we got sunglasses indoors. Already not liking this person.
What have we determined?
Yes.
Good evening. Well, good afternoon, brother.
Yes.
All right.
First, I know Mr. Johnson was able to speak to one of my colleagues when I was in court this morning. We will be, I know we have a green sheet in there. He will be waiving his PE for this to go over to circuit court. I will have him fill out that form momentarily, Your Honor.
So he's waiving up.
Yes, he'll be waiving up.
All right. Is there any issue I need to do with bond on this then?
Your Honor, at this time, we would be asking for a no contact order to be put in place.
I thought you did give the change this morning.
First name induced, Your Honor.
Okay, help me. Name. Yes. I need counsel. Go ahead.
If he's actually blind, then we've all earned.
Yes.
We've all earned
in
the hate.
addressing the prosecution's request for no contact, I'll be saying per his probation cases, he does have a consensual contact order with the complaining witness in those cases. She did make a 40-minute victim's impact statement confirming that she did want contact. I can confirm this with his APD who represented him at the circuit court level. Judge Conkey there made a determination that contact would be proper if it was consensual contact. Similarly, this was a request that was made at arraignment on this case. I was not myself who handled it, my colleague. However, Magistrate Otella there also made a determination based upon the allegations related to this case, which is two R&Os and alleged two R&Os and a possession that no contact order was needed. The alleged complaining witnesses in this case before you at this moment would be the police officers, not the complaining witness from his past cases. So I'll be asking for no modification in his bond.
But you would agree that between the time of the arraignment, well, between the time of Judge Conkey's hearing, the time of arraignment on this case, that certain circumstances have changed regarding that contact. Meaning phone calls that were made, which one could look at as interfering or otherwise attempting to try to obstruct this proceeding.
While context may be changed, he has indicated that prior to this, he was never near her. I understand the concerns that you're addressing with these phone calls. However, again, they are still not a evaluation of his previous probation. So
right, okay, so that we're not getting, so that we're clear in what I'm saying. I'm not saying that they're necessarily a violation because the no contact does not exist. I guess I'll put it that way. I mean, it's permitted.
I didn't, you know what? I didn't even think, I didn't even think about his lawyer being hearing impaired. I just thought he may have have a speech impediment. I didn't want to say anything.
Contact. But once that contact then begins to happen, the subject matter of that particular contact, what's said, could change those circumstances, I guess, in terms of whether or not contact should continue to be permitted. I mean, if somebody calls and is making either threats or some other type of statement to someone.
Hitchbot, do you hear about the kerfuffle with the California bar exam? Is that the latest video from Legal Eagle? I haven't seen it yet, but just based off of the thumbnail, I am so glad I took the bar when I did before all this AI mess came to screw up everybody's education.
That could lead the court to then change the bond conditions on the case. You would agree with that, would you not, Mr. Buckovich?
yes, I would understand what you're saying here.
All right. Okay. Anything else regarding this case? I'll take the waiver in a moment. You're gonna wait. He's waving up.
Yeah, but you get in front of Conky.
You know what, Your Honor, I might as well just wave up to Conky.
Okay.
Okay, if that's what you wish to do. Sir, you.
That was me addressing bond, but not changing when it was no contact with her. That's what I was addressing. I'm not gonna be right towards you.
Okay.
Just one more time to reiterate for the purpose of bond. Those calls can also not be interpreted in a way that is non-threatening. So I would still be asking for a.
You're saying they could be interpreted as a way of non-threatening?
Yes.
Okay.
So I would still be reiterating that I would be asking for no modification in bond and no contact order to be put in place.
Is there anything from the people on that?
There is, Your Honor. So first of all, I want to point out that at the arraignment with Magistrate Odosella, Mr. Buckovich and I were both present. As he mentioned, it was his colleague that handled the arraignment. There was not an extended back and forth about the no contact provision. We made the request, it was articulated on a recommendation form, and the magistrate declined to order it. But there was no, honestly, it could be that it just slipped his mind in terms of that being a request, and I maybe should have done a better job of reminding him about it. But I want to point out there was not an explicit denial of that request on a basis of it not being necessary. Second, I understand that this was prior to sentencing. In the GBH case that Mr. Johnson had with this same victim, I understand she's not a victim in this case, he previously had an issue.
Lane, thank you for the 199. Appreciate it.
Where his wrong privileges were revoked first. Then there was a motion for forfeiture by wrongdoing. It ended up not being necessary because the case was bound over at exam. He continued to contact her after that, discussing the fact that she did not want to cooperate with the exam from different people's pens. So it's an ongoing problem and it's an ongoing pattern with this case. He made some comments at the arraignment on this case that quite frankly raised the red flag for me with the concern that we were going to end up right here like we are today. The people are requesting a simple no contact. It's unclear to me. I understand that consensual contact was granted by the circuit court. That was in January of this year when he was sentenced on that GBH case and on the possession of methamphetamine case as well. He is charged today on this case with another methamphetamine case and are now emanating from this victim, articulating concerns about her safety with him. We think that the circumstances have clearly, if they were deemed to be appropriate back in January have certainly changed by now. So the people are, again, requesting a simple, but straightforward, no contact whatsoever with this complaining witness in this case. Given the history here and the fact that we have a pattern established of a failure to abide by bond conditions beyond the revocation of previous phone privileges.
Wow. All right, here's what the court's gonna do.
Okay.
Well, is he waving up or what's he gonna do?
Mr. Bennington?
Or did you wish for the adjournment, Mr. Brown?
Your Honor, I'm quite confused on a couple of things. If I'm able to speak to you for a second. The complaining witness of who they are talking about, I understand my attorney's sitting right here and he's present in front of me. I'm speaking on my behalf. She went in front of Kunke.
Oh my God! Wait, he is actually blind, isn't he? Or at least he's trying to pretend that, or at least that's what he's giving out.
Judge Kunke, and admitted to her full honest truth that I did not assault her, harm her in any condition or form, okay? And also even stated that drugs were planted inside of a book bag, Your Honor.
Oh
planted
boy!
Inside of a book bag. This is on
Oh, no.
transcript in Kunke's courtroom, Your Honor.
Shut up!
And by not being able to have contact with her is, I'm confused on it. I'm not being explained or talked to the reason why I cannot have conversations with my fiance and soon-to-be wife.
Oh boy!
When this drug charge had nothing to deal with her, it had to deal with a
But you making statements to her that the reason behind your predicament, and I'm paraphrasing this and putting it, is because of what she did are problematic.
What she did?
Because that you're in the circumstance you're in because of her. Those are problematic comments.
Okay, so that's the reason why I'm not able to have contact with her.
Yeah.
She didn't put me in this predicament. Her doctor
Sir, I
did a
advise you
welfare
stop making
check on her.
statements. I advise you stop making statements. Because this is related to this case.
Is their attorney like, shut up, shut up, shut up, shut up?
And can you speak more?
Sure, I've explained that. So statements can be used against
Do
you.
you wish for me to adjourn this rather than to
No,
waiver?
give me the pen. I'll go in front. I'll go in front of council, man. Have yourself a good day.
Really hope he didn't run or act that way. So you signed this waiver of preliminary examination?
Correct, Your Honor.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yeah, I do, Your Honor, even though there wasn't one committed, but yes, I have to.
I'm not taking his waiver. I'm just going to adjourn this out.
Yep.
You can talk to your client. He can figure out what he wants to do. I'm asking very simple questions. He seems to get angry at me. I don't even know why. I'm making the findings based upon what's presented to me. But if he's going to act this way, I'm just not having it. So.
Would you like to briefly pass this matter so I can speak to my client?
I'm not going to pass it. I'm going to adjourn this to another day.
I'm not mad.
I'm going to adjourn this to.
Don't interrupt the judge.
Give him 1 week out. We'll go June 5th, 2025. 9 a.m. As invite indicates, I am at this time going to change the bond conditions. I'm going to leave his bond in its monetary amount as it's set. I am going to order that his phone privileges at this juncture are revoked. You could bring that up again at the next hearing. I'm also going to indicate that there's no
Erica, no, I did
with
not.
Christian Kanuski. I'm going to order that at this point, and then he can decide what he wants to do with the case. But if he thinks I'm going to put up with his behavior, I'm not doing it. I'm done.
Your Honor,
Thank you.
I'm not upset, Your Honor. I said just. Okay.
This.
Not even upset.
What an idiot.
Court does call the cases of the people versus Quincy Jones.
Quincy Jones. I feel like Quincy Jones would be the perfect name for like a hip hop producer. I don't know. That's what just screamed out at me just now.
That is on behalf of Mr. Quincy Jones, who is approaching. Can you put it on the record?
Quincy Jones. All right, he has a new case, you know that.
Yes, Your Honor.
All right. So, Mr. Jones, you have a new case currently, okay? And you're before the court on a complaint that alleges that on or about March 14, 2025, at the location of South Huron in Michigan Avenue in Ypsilanti City, that you did knowingly and intentionally possess less than 25 grams of a mixture containing cocaine. Do you understand that charge? I'm not saying whether or not you did it. I'm saying, do you understand what you were charged, what you're charged with? Okay. Do you?
Okay.
I understand that. All right. That is a felony punishable by up to 4 years incarceration, $25,000 fine plus court costs. You understand that? Mr. Jones, let me ask you something. If I had you tested right now, you gonna test clean?
Oh, damn it. Yeah. I feel like Judge Simpson's been on the bench long enough that he's able to tell.
For what?
I don't think that's a good answer. A clarifying question, Your Honor. For what?
Mr. Allen. Mr. Jones, what's going to be in your system? Because I can't arraign you if you're under the influence of something. So you might as well just tell me. Marijuana. And what else? Copy of the cocaine.
Marijuana and probably a little bit of cocaine.
Probably a bit of cocaine. When did you take that? Be truthful with you. Huh? Yeah, I'm be truthful with you. Okay. So when did you take the cocaine? About 2 days ago. So it ain't on my system. Seriously? Yeah. So when's the last time you had any marijuana? You're on something. You're on something right now. What are you on? That you. What do you mean? Like, the worst thing is to lie to me. What do you mean? What do you mean? Like on something? Like, what do you mean? Like, did I do something to get today or? I don't.
Oh my god! I feel like that's all the answer we need.
I think that's a really hard question. Oh, I smoked some marijuana last night. Tell you what, it's real clear to me that you're on something. I'm not going to arraign you on new charges. I'm not.
What? Father, once I thought I had a slam dunk annulment because my petitioner suggested the respondent was stoned at the wedding ceremony, but she later recanted. Oh no. Sydney, thank you for the membership. That's wild.
I'm not going to do anything with these other charges. I'm adjourning all of this over to next week. But right now, on your one case, your bonds revoked, defendants remain.
Get yourself cleaned up a bit.
Why? Good. That works. And I'm going to set that for the 5th. Court does call the case. People versus Elliot Kazan.
Christina, they're here for the people.
Wow. How'd you get over there? What, did they kick you out over there?
No, Your Honor.
So why are you over there?
I'm with Miss Lundy, Your Honor.
Why is she?
There's a lot of us.
There are. This place is packed with prosecutors.
For the record, Your Honor, Joe Simon, on behalf of Mr. Kazan, state your name, Elliot.
Elliot Kazan.
So Ron's trying to catch my reflection.
I'm presuming you have the violation.
Yes, Your Honor. We.
Why don't you approach?
Yes, that's what we're going to ask. Thank you. Apologize, what takes. Okay.
All right. In this case, we do have a bond violation report, which indicates numerous missed tests. But then makeup tests were negative for alcohol or late test, with the exception of the 24th, at which point there was a missed test.
I got a sitter.
Tested and showed up with alcohol in the system.
Your Honor, I've discussed these issues with Mr. Kazan. He's going to admit to the court to consuming alcohol. I don't know if it was the 23rd segue into the 24th, but whichever that day, in violation of his bond, he's going to not try to deny it. He's going to claim full responsibility. We have some requests as a result of that, but first, I think that he's ready to address his.
And that's correct, so you admit to this violation?
Yes, Your Honor.
I will not take his plea today. I will adjourn the probable cause conference out to June 5th, 2025 at 9 a.m. And what did you want to say before I sent him?
Your Honor, my client has been screened and assessed with Matthew Statman. That's the provider that the remand court uses. He has made arrangements for his recommended outpatient treatment. It took a while due to backlog, but he's pushed it up, and he's got, if the court would permit him, 9 a.m. tomorrow at UMATS, which is the University of Michigan Alcohol Treatment Services or something like that, or I can't remember the full acronym. Anyway, at 9 a.m. is his intake. Okay. Additionally, I told him that continued SoberLink testing is not recommended for him, that even though it's summertime, scrams can be uncomfortable, particularly when we stop wearing long pants necessarily, et cetera. That would be the only.
How do you pronounce? My understanding is that you pronounce it as you. So I would say you Dawes.
Thing that the court might entertain in terms of making sure he's not a risk to others or a danger to himself. He said he would happily do that immediately, turn in his SoberLink and put on a scram and wear that. So that is our request, Your Honor. I told my client that the court in this situation typically revokes somebody's freedom, revokes their bond and incarcerate them. He's prepared for that eventuality, but hopes the court will consider our request, our alternative request.
The court looking at it, and we had been to conference about this, I think, when I looked through and there's a missed test, I also am concerned with the fact of the blood alcohol level at a 10 o'clock a.m. testing, which tells me that there's probably a whole lot more going on because he had previously missed the other, or had missed the testing at 7 a.m. So when I look at it all, that seems to me to be a big problem in terms of a gap. And I think there was a lot more alcohol consumed than what this one PBT indicates. At this time, given that the defendant has admitted to the violations and violated his bond, the court is going to revoke the defendant's bond. Defendant's remanded to the Washington County Jail. So we'll see next.
Also unsurprising.
Court calls the case People versus Lozelle, Washington.
Yeah, one more.
Deputy for the people.
Good morning, Your Honor. Edward Drukas on behalf of Larzell, Washington. Approaching.
Your name, sir?
Larzell, Washington.
Thank you.
Sir.
The court has before the plea form. Is that what we're doing?
Is he also blind?
Today?
Yes, Your Honor.
The plea form indicates that the defendant would be pleading no contest to the charge of receipt and concealment of stolen property, 200 to 1,000 to 1 year offense. Upon a successful plea to that charge, count one would be dismissed. That's the court's full understanding of the agreement. Is that correct?
That's correct.
That's correct, Your Honor.
And you have him sworn.
Raise your right hand. You solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing so help you God.
Yes, sir.
State your name.
Larzell O'Neill, Washington. Sir, it is this court's understanding that you're going to be pleading no contest to the charge of receipt, concealment of stolen property, $200 to $1,000. That is a misdemeanor, punishable by up to 1 year incarceration, a $2,000 fine plus court costs. Fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that, sir? Yes, sir. Do you understand what a no contest plea is? Yes, sir. You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court. You understand that? Yes, sir. Basis for the no contest plea?
Civil liability.
Sir, to that charge, how do you plead?
Guilty, sir. No contest.
I was
You
gonna
understand
say,
that by pleading no
wait, did you just say you're gonna plead no contest?
contest, you will not have a trial of any kind?
No, Serrano, why?
Yes, sir. You signed an advice of rights form, is that correct? Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today to get you to plea?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily
Yes, sir.
of your own free will?
Yes, sir.
And because you believe, well, I won't ask you that. Court has been provided and has reviewed Washtenaw County Sheriff's Office report for their case number 24-62111.
Try taking it again.
Any objection to the court having reviewed that report?
No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt. Counsel, have I complied with the court?
People are satisfied.
Defense is satisfied.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. July 3rd, 2025, 10 a.m. before Judge Washington.
If I may address Brown, Your Honor.
Go ahead.
Mr. Washington previously was remanded for, or I had been picked up for a warrant for failing to show up to court. I have had several discussions with him, gone over this case, gone over what happened at his sentencing. He did interview with the recovery court. And now with him going to 14B for sentencing, I'm going to assist him with getting the paperwork ready for probation. He knows he needs to make and keep an appointment with probation. We're not objecting to any additional orders the court would impose if the court would require him to test a community corrections. He would abide by that. He reports to the court today that he would show up to that sentencing, that he's tired of being tired, and he wants to take care of this. So we're asking for a PR bond. He has spent about 30 to 40 days in jail since he was picked up. And I think he understands the consequences of him not showing up to court, and the fact that this was reduced from a serious felony to a misdemeanor. We're asking for that reduction to a PR bond.
Response from the people.
Thank you, Your Honor. So my only requirements for the reduction in this case was that Mr. Washington participate honestly in the screening and referral process for the treatment court. I believe the court had the outcome of that screening interview. I don't have the full assessment report, but I wanted to get some sense of where he is. I have not taken a position on him being released thus far. The only request that I have is that he be ordered to test for drugs and drugs, specifically alcohol, I suppose optional. Especially given the outcome of the interview, Mr. Washington was very adamant about not participating in treatment court, so I do want to ensure that he at least remains compliant.
Yes. Bond will be reduced to a $25,000 personal charge since defendant to test 2 times per week at community corrections. You understand that, sir?
Oh, yes, sir. And thank you, Justice.
Well.
Don't think we yet.
Don't show up. I don't know. Judge Washington would be so generous. If
I'm gonna
show up. Sure. All right.
Thank you.
You got to make sure that you test.
Yeah. I mean, a $25,000 PR. I mean, PR means that he doesn't have to pay anything. But if he messes up, that's a lot of money. Okay. I'm going to stop it here. And I'm going to test and be disappointed in my latest attempt to fix my GPU. I'm probably not going to stream at all tomorrow because I'll be working in the morning, and then I'll be heading out to traveling in the afternoon, evening. And then we, let's see, what do we do? Our boarding time on the ship is at 12:30, and and it's anchors up at like 3:30. So, all right. We're shipping off from Miami. Going to, I just looked at my itinerary. We're going to the Royal Caribbean's like private island, the Coco Cay, St. Martin, and St. Thomas. So, all right. I'll see you guys when I'm in Maritime Admiralty Law. And yeah, see you guys later. Thank you for watching. Appreciate it. See you on the boat. Bye. Let's hope to God this thing works. Ah, Dios mío. I think I'm fully packed too. I think I'm packed. Yeah. Sure. I'm pretty sure I'm packed.